Good morning, Sat Sri Akal, Adab, Namaskar. Friends, this is my 164th video. It is again covering cases of resumption. Now we will go on a property which belongs to Jabalpur and was a lease under section 264 of the Cantonment Code 1912. This was a lease in perpetuity, very clearly written, free of rent, Bungalow number 8, Theatre Road, Jabalpur. The original lease was measuring somewhere approximately 2.02 acres, survey number 99, and this lease was made in March 1922 in favor of Sidney Alexander Bellary and Jesse August May Bellary. Now, this property changed hands in November 1957 with the present owner Bajrang Prasad. What is the case about? The lease in perpetuity was purchased for rupees 22,000 rupees and by the permission of the government. Then further on in 1963, as the bungalow was in a very dilapidated state, a permission was given and a separate lease was made for some approximately 3,337 square feet in 1968. Now we must understand the total property is 2.02 acres. A sublease is made in 1968 when the owner is asking for permission of reconstruction. Now the petitioner was given a resumption notice under which clause? A lease in perpetuity. I have been continuously speaking that all leases, whether in 1899 or 1912, they carry a resumption clause. And this clause is under section clause 27. So the bungalow, finally the government thought of resuming. The old and new structure involving the owner wanted somewhere around 1.45 lakhs for the property. The government was not willing for that amount. It gave a meager amount of some 8,000 rupees for the structure standing on. Now I'll read this clause of the contract under which the resumption of the land is claimed reads as under. Rights of the government to resume the land on payment of compensation for buildings. The local government may resume the land or any portion after giving 1 month notice in writing and on payment of compensation for such buildings standing on the land or proportion thereof as shall have been erected under proper authority. If there shall be any dispute as to the amount of such compensation, the same shall be referred to the Committee of Arbitration, which shall be constituted or provided in Chapter 20 of the Cantonment Code 1912, and the lessee shall be bound by the decision of the Committee of Arbitration. The notice of resumption was issued on 23rd April 1970. A covering letter of MEO Jabalpur for the bungalow was handed over on 28th May 1970. And immediately the petitioner came to the court. Now what did he plead? What was his contentions? Right has been conferred upon the local government. So the petitioner is pleading that after the Government of India Act 1919, the right to resume lands was under the local government. Now what is the OGB? Now what is the owner speaking? The local government under the context would mean the provincial government or the state government. Though the lesser were the Secretary of State for India, that is the central government, the lesser did not reserve to themselves the right of resumption, but conferred the said powers upon the local government. The lease was executed in 1922 when the Government of India Act 1919 held the field and local governments were understood to mean the provincial governments. The Act of 1919 dealt with the provisions relating to local governments in Part 5. The petitioner says that the notice of resumption ought to have been issued by the state government. The notice was issued by the central government. Now, this is why it becomes inoperative. So, what is this point? Pleading? It's a very important pleading under the 19 Government of India Act 1919. But what does the court interpret? It is pertinent to mention, and the intention is drawn on the Government of India, adoption of Indian Laws Order 1937, which directs that throughout the Cantonment Act 1924, save as otherwise expressively provided for local governments, the word central government have to be substituted. We may also like to mention that in the Code 1912, the expression local government meant the Government of India. The Government of India Act 1858 recognized whole government, that is the Crown and the Secretary of State in England and the Governor General in Council in India. The expression local government, it appears a refer to the government other than the home government in England. The Act of 1858 does not refer to any provincial or local government in that sense. So this pleading is null and void. Friends, why am I talking about these cases? It's a very simple logic. If we get 101 cases, people talk, advocates brief, what are we pleading? Has this point been pleaded? If it has been pleaded, vetted by the court, it is null. It's of no use. The second contention, what the petitioner is pleading, is that the notice was wrong. Both the description of the land sought to be resumed, as also the mention of the dates of the original lessee and the supplementary lease. Now he is going back to 1922 lease under the 1919 and the 1968 lease. So a little discrepancy on technicality is being. So here also what the government is saying, this confusion of the notice goes to the root of the resumption proceedings. So that means the department abruptly, arbitrarily is doing this. The third and the most important contention the petitioner is that the offer of 8,000 rupees was both illusory and arbitrary. The petitioner had purchased the property for 22,000 with permission. They spent 45,000 on additional construction. The cost of construction was going very high. The building is worth more than 1 lakh. So the offer of 8,000 is unreasonable. So these two basic judgments were discussed in this case. One was the Allahabad High Court judgment of Bhagwati Devi, and the other case was of Raj Singh of Meerut. So what is the petitioner or the owner trying to prove? In the present case, the instrument is a lease, and the determination of the lease is permitted to the lessor subject to his giving a month's notice and paying the compensation on the land. The obligation to pay such compensation comes under the principle of natural justice. It's very simple. During those days, this kind of a natural justice was generally being adhered by most of the courts before they are required to go to arbitrators. Now, this is a very important point. They must know the details upon which the compensation was worked out. The valuation must be such as could prima facie be sustained in a court of law. So, a similar case of a Jabalpur cantonment was discussed in this case. The petitioner are the owners of bungalow number 4, Howbag Road, Jabalpur, Kent. The original lease of the land sought to be resumed was granted to the petitioner's predecessors in title. Lease dated 21st September 1908 under the provisions of the Cantonment Code 1899. Now this bungalow number 4 is being discussed in this bungalow of Bajrang Prasad. The petitioner had purchased the property in August 1927 for 30,000. The present value as per the petitioner was more than 1.5 lakhs. The central government gave a notice on 15th January 1973 that they had decided to resume the land by paying a compensation of a meager 4,590 rupees. They asked the petitioner to deliver the property in 30 days as per the resumption notice. The petitioner went into arrest, challenged it. The petitioner in that bungalow number 4 raised 2 points. That the notice of resumption should have been issued by the local government, which under the context would mean, according to them, the state government. That the leasehold rights could come to an end only upon payment of compensation determined after due notice of the petitioner following. Similar. Now you bungalow number 4 and present Bajrang Prasad. If you see, there is no difference. So what are we running on to? Bungalow number 4, bungalow number 8. Now people sitting in Jabalpur would be more aware what is the status of this bungalow. Bungalow number 8, I know. I have been in touch with Mrs. The lady who is now the present owner. Her husband died. When we visited Jabalpur, we met them. So these facts, what is the status of bungalow number 4? What is the status of bungalow number 8? Bungalow number 8, I was even shared with the SLP which was filed number 1944 of 1977. 5 by the Union of India after losing. Here what the Union of India does, after filing the SLP twice over on the notices, till 1994 does not reach the Supreme Court. Finally in 1994 the Supreme Court dismisses the SLP. So the bungalow, what is it? That means the resumption notice is quashed. Nothing is left. Fought on merits, res judicata, so this property becomes a freehold property. Section 27 is null and void. What? So these are the questions which need to be raised, which need to be asked, questioned. So people in Jabalpur can do this. I can't sit everywhere. I can is only, see, I am working on a mindset where I know what are the loopholes in this case. I know what is wrong and what is right, either from both the sides. But here the government is behaving lazy. It is in a lethargy mood. Guys, because we are old grants, we were never converted into new grants. My thumb rule will always remain same. We were revenue free grants. Whether we were converted from old grants into leases in 1899 or 1912 and further on 1925. Every bungalow owner, a lessee, has to find out what on left, what on right is an old grant of his. Till he doesn't do that, he's got nothing to fight on. This regulation under section 27, he will stand resumed. Thank you.